The presidential pardon, one of the most potent and controversial tools of the U.S. presidency, represents a balance between justice, mercy, and political reconciliation. Rooted in the U.S. Constitution, its use has shaped historical and modern narratives around accountability and forgiveness. This video explores the pardon's origins, its evolution, notable applications, recent controversies including Joe Biden, the sitting president's son, Hunter Biden's pardon, and its prospects in politically charged cases like Donald Trump's. Origins and constitutional basis. The presidential pardon originates from Article 2, Section 2, Clause 1 of the U.S. Constitution. The President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. This clause is modeled after the British monarchy's prerogative of mercy. Defended by Alexander Hamilton in Federalist No. 74, the pardon power was intended to temper justice with mercy and facilitate national unity during crises, such as rebellions or insurrections. Comparative perspectives around the world. Many developed countries grant similar clemency powers to their heads of state or government. For example, United Kingdom, the royal prerogative of mercy allows the monarch to grant pardons, typically advised by ministers. Canada, the Governor-General, under the letters patent, can issue clemency based on ministerial advice. France, the President can grant individual pardons, primarily for humanitarian reasons. Germany, state and federal presidents can pardon crimes. Australia, governors and the Governor-General can pardon individuals in line with state or federal laws. These powers are often more regulated than in the U.S. to ensure checks and balances. Purpose and wisdom behind the power. The pardon power serves several critical functions. Correction of judicial overreach. Pardons allow rectification of legal penalties deemed excessive or unjust. Mercy and rehabilitation. They provide relief to individuals who demonstrate reform or remorse. National reconciliation. Pardons have historically been used to heal political divisions, exemplified by post-Civil War amnesties. Scope and limitations. Federal jurisdiction. Pardons apply only to federal crimes, excluding state offenses. Forms of clemency. Full pardons, forgiveness of offenses and restoration of rights. Commutations, sentence reductions without nullifying convictions. Amnesties, broad-based pardons for political or social reconciliation. Timing and conditions. Pardons can be issued before, during, or after legal proceedings but do not apply to impeachment cases. Notable pardons in U.S. history. Richard Nixon's pardon. In 1974, President Gerald Ford pardoned former President Nixon for crimes associated with the Watergate scandal. Ford justified the decision as necessary to heal national divisions but faced significant political backlash, with critics arguing it undermined accountability. Posthumous pardons. These demonstrate the moral dimension of the power. Henry O. Flipper, pardoned by Bill Clinton in 1999, Flipper was the first black graduate of West Point and wrongfully court-martialed in 1881. Charles Winters, pardoned posthumously by George W. Bush in 2008 for aiding Israel's fight for independence in 1948. Presidents who pardon thousands. Several U.S. presidents have used the pardon power extensively, issuing thousands of clemencies, often for similar reasons. Calvin Coolidge and Warren G. Harding pardoned many individuals convicted under harsh prohibition laws. Franklin D. Roosevelt pardoned over 3,600 individuals, primarily for alcohol-related offenses stemming from prohibition laws, even after prohibition ended. Harry S. Truman issued over 2,000 pardons, many for those convicted under prohibition, as well as for deserters and draft evaders during and after World War II. Barack Obama pardoned over 1,700 individuals, focusing on nonviolent drug offenders, addressing racial disparities in sentencing, particularly for marijuana-related convictions. These pardons often aimed to correct past legal overreach and provide second chances to individuals impacted by outdated or unjust laws. Hunter Biden's pardon. On December 1, 2024, President Joe Biden issued a full and unconditional pardon for his son, Hunter Biden. The pardon addressed tax violations and gun-related charges over a period of nearly 11 years. President Biden stated his son was unfairly targeted due to political pressures, sparking a contentious national debate over the ethics of familial pardons and the perceived misuse of presidential powers. Speculations about Trump's potential pardon. The president-elect, Donald Trump, facing multiple legal troubles, remains a polarizing figure in discussions about the presidential pardon. While President Biden has not indicated plans to pardon Trump, such an action could aim at national reconciliation but might alienate Biden's political supporters and challenge notions of justice. Criticisms of the pardon power. Potential for abuse. Pardons can be wielded for personal or political gain, eroding trust in the rule of law. Lack of oversight. The power is unchecked by Congress or the judiciary. Undermining justice. High-profile cases, including Hunter Biden's, invite allegations of favoritism and diminished accountability. Analysis. Balancing mercy and justice. For the pardon power. Pardon is vital for correcting injustices, humanizing the law, and fostering national unity. Examples like Nixon's pardon illustrate its ability to prevent prolonged societal discord. Against the pardon power. Its unchecked nature poses risks of politicization and undermines the judicial system's credibility. Transparency reforms, such as advisory boards or mandatory justifications, could mitigate these issues. Conclusion. The U.S. presidential pardon is a powerful but controversial tool that underscores the tension between justice and mercy. While its historical use highlights its capacity for good, contemporary controversies reveal its vulnerabilities. Addressing these flaws through oversight and reform is essential to preserve the institution's integrity in a modern democratic society.